Hi, Jim Selbach. Today I'd like to talk about, I guess, one of my pet peeves, and that is the issue of, does a debtor have some obligation to warn a creditor before filing a willful violation motion? And the answer is clearly no, but it comes up a lot, okay? First of all, if the creditor was listed and if the address is right and enough time has elapsed so that they have received the notice, they've already been warned. The 341 notice, if you look at it, has extensive language about what you can and what you cannot do, and if you do that, you could be sanctioned. So there's adequate warning. So the idea that you have to give additional warnings is kind of saying you have to be warned twice. Now, here's what former Chief Bankruptcy Judge Stephen D. Gerling said about this issue. It's not the debtor's responsibility to take action that ensures that she receives the protection of the automatic stay. Rather, the creditor bears the burden of seeking relief from the automatic stay before taking post-petition collection actions. The debtor has already met its obligation when it properly lists the creditor with the address, because that's the debtor's obligation. Make sure that every creditor is listed and the correct address is used. Once they've done that, it shifts back to the creditor. The creditor doesn't have to be warned again. Now, I had a case back with Judge Gerling in which the creditor actually said, you have to give us a warning shot, a shot across the bow before you make that motion. And here's what Judge Gerling said. Such a requirement would place an unreasonable burden on the debtor to forewarn the offending creditor to cease and desist before debtor's counsel could reasonably file a Code 362H motion. It's now 362K. And this is the point. The creditor has already been warned. The statute does not have any requirement of a warning before filing a motion. The problem is the practice has been at least in this district and other districts for so long that you have to warn them first. Well, first of all, in my experience, because I ran a high volume bankruptcy practice for over 32 years, they ignore those letters. So you send a letter out, please stop violating the stay. If you don't do it, we're going to file a motion. They don't pay any attention to those. The only way you actually get enforcement of the stay is to file a motion. That's been my experience. So here's what another court says. Where facts indicate a willful violation of the automatic stay, it is improper to impose a blanket rule on all debtors requiring them to notify creditors to try to resolve the violations prior to filing. There is no requirement to do that. Although there are cases that say that there is. I don't think they're right. If Congress wanted to impose some warning as a condition to bringing the motions, it knows how to do that. For example, under the Fair Credit Reporting Act, when there's something wrong on your credit report, before you can sue the credit reporting agency, you have to notify it and you have to give them an opportunity to fix it, or you can't sue. Or how about Section 9011 or Bankruptcy Rule 9011? You get a frivolous motion. You think it's frivolous. You think the attorney should be sanctioned. You cannot file that motion until you give that attorney an opportunity to withdraw it first. So if Congress wanted to have some requirement that you had to warn first, it knows how to do that. But there is no such requirement under Section 362K.